Thank you, Mr. Speaker. First, I want to address House Bill 3309, the Innovation Act, which is generally a good bill. It's trying to deal with issues of nuisance litigation, where somebody is sued and the costs of litigation are so extreme that they pay money just to stay away from litigation. That's really the underlying purpose of the bill. Now, what we've got to make sure as members of this House and as members of the legislature, that we don't advantage one party over another. And I see the gentleman from California, Mr. Rohrabacher, made a good point, Mr. Speaker, last night at the Rules Committee, that you don't want to disadvantage small inventors who've come up with a good idea or a great product, something very novel, and some major corporation takes that idea or that product away and doesn't pay for it. That's the purpose of patent litigation. At the same time, you don't want to have some small company that buys a Wi-Fi service all of a sudden getting sued by some company they never heard of, and they're saying, wait a second, we're not a patent infringer. I say all of this because the purpose is to have good litigation where there isn't extortion and there isn't theft as a result of some patent infringement. What's done in this bill, I think, though, is micromanagement of the courtroom and its processes. Each of these cases stands and falls on their own merits, and the courts are best equipped to determine their own rules and their own procedures as to how these cases should move forward. I'm generally going to support this. I offered an amendment which was not adopted by the Rules Committee last night to delay till December of 2015 so the effect of Section 6 of the bill so that the courts could create their own rules and not have the legislature do it. 100 years ago we passed the Rules Enabling Act, which allows the courts to set their own procedure, which is then overseen by the legislature. That is sort of discarded in this bill, and we create some very specific rules, and I think that's a mistake, and I think we could have some real winners and losers, and I think the small guy, the small inventor, the small purchaser could be in trouble. So I would just suggest to the House and to the Rules Committee that we do look at delaying so that the courts can offer their own procedure.